Statutory interpretation concerns how judges interpret or give meaning to acts of Parliament. So, ultimately, it's the judges who determine what an act means, even if they claim they are simply giving effect to Parliament's intentions. The key areas of statutory interpretation which you will have to learn are uncertainty and ambiguity, the literal rule, the golden rule, and the mischief rule, the language rules, presumptions, the purposive approach, and intrinsic and extrinsic aids. You might ask why judges need to interpret acts of Parliament. Isn't their meaning obvious? The answer is no. Language itself is an imperfect medium of communication, and there are often problems with the drafting of legislations, and difficulties may arise due to the use of words, which both have a technical and a non-technical meaning. Uncertainty is a problem which arises because it's unclear whether a particular word or phrase used in a statute cover the factual situation before the court. Single words such as type, park, vehicle, etc. have all given rise to uncertainty. For example, in Brock versus DPP, the argument was whether a dog could be classified as a dangerous dog under the Dangerous Dogs Act 1991. The problem was with the word type in the phrase, any dog of the type known as a pit bull terrier. The issue was whether the word type meant the same as breed. The court decided that the word type was wider than breed and covered dogs which were not pedigree pit bulls. Ambiguity is a different category of problem. Here, the difficulty is caused by statutory words that have two or more meanings. The classic example of this is in the case of Fisher versus Bell. A shopkeeper displayed a flick knife for sale in his shop window. The relevant legislation made it an offence to offer for sale such an offensive weapon. The issue was with the meaning of the word offer. The shopkeeper appeared to be in breach of the law because in a non-technical sense, the knife was being offered for sale. However, in contract law, the word offer has a more technical meaning, and the court decided that the goods on display in the shop window did not constitute to an offer in a technical sense. Thus, the shopkeeper was found not guilty, and the apparent purpose of the act defeated. Many commentators prefer to call these canons guidelines or principles of interpretation rather than rules because a judge is not obliged to follow them or to apply them in any particular order. Judges have not been able to agree on a single approach to interpretation. They have developed three main rules: the literal rule, the golden rule, and the mischief rule. The literal rule definition. The words of the statute must be given their plain, ordinary, natural meaning, because the best way to interpret the will of Parliament is to apply the literal meaning to the words they have used, even if the result doesn't always make sense. Let's look at two classic examples, Whiteley versus Chapel and London and North Eastern Railway versus Berryman. Firstly, in Whiteley versus Chapel, legislation made it an offence to impersonate any person entitled to vote. The defendant was acquitted because he pretended to be a dead person, and a dead person, quite literally, is not entitled to vote. In London and North Eastern Railway versus Berryman, a rail worker was killed by a train. His widow claimed damages under legislation which stated that compensation could be paid to employees killed while relaying or repairing tracks. The worker had been doing routine maintenance and oiling the points, which the court held did not fall literally within the meaning of relaying and repairing. Let's look at the advantages of the literal rule. Okay, so it limits judicial lawmaking, leaving this to the elected representatives of society. It therefore also recognises parliamentary supremacy and sovereignty. It gives words their plain meaning, and in so doing could be said to be based on good faith, in terms of giving effect to Parliament's intentions. Disadvantages of the literal rule. In reality, cases like Fisher and Berryman produce absurd and unjust results, which can't have been the intention of Parliament. Secondly, the meaning and aims of an Act of Parliament extend beyond individual words into broad areas of policy. The rule does not recognise this. Thirdly, the rule assumes unobtainable perfection in draftsmanship. And finally, as Professor Zander has observed, the rule is mechanical, divorced both from realities of the use of language and from the expectations of the human beings concerned. The Golden Rule. Okay, so the definition. The court starts with the literal rule, but if this produces an absurd result, which Parliament could not have intended, then the court need not follow the literal interpretation. The Golden Rule is a gloss upon the literal rule. In R versus Allen, the issue was the interpretation of Section 57 of the Offences Against the Person Act 1861, which dealt with bigamy. The section stated that an offence of bigamy occurred where someone being married shall marry another person during the life of the former husband or wife. The argument concerned the word marry, which has two possible meanings. Firstly, to go through a marriage ceremony, and secondly, to contract a valid marriage. The defendant admitted that he had been through a marriage ceremony, but argued that the statute meant to contract a valid marriage. As he was already married to someone else when he went through the ceremony, then, by definition, he could not contract a valid marriage. To avoid this absurdity, which would have defeated the purpose of the legislation, as none could ever commit bigamy, the court held that marry meant to go through a marriage ceremony. This case is often taken to represent the narrow view of the Golden Rule, meaning judges can only apply rules to situations where the word has several possible meanings, and their job is to choose the meaning which will produce the least absurd result. Thus, in Adler versus George, the defendant was charged with obstructing a member of the armed forces in the vicinity of a prohibited place. He claimed that the literal meaning of in the vicinity was near to, whereas he had been in the Air Force Base itself, the prohibited place. The court accepted that in the vicinity could mean near to, but that would produce an absurdity, and therefore, in the context of the Act, it was necessary to interpret it as meaning within the place itself. However, the broad view of the Golden Rule is this. Even where the words have one clear meaning, the Golden Rule can be applied if the result of the clear meaning would be unjust or unacceptable for some other social or moral reason. In Re Sigsworth, a son murdered his mother. She died without making a will. The relevant statute was clear. Where a person dies without making a will, the estate is inherited by their next of kin or issue. The son was the next of kin or issue. The court applied the Golden Rule to prevent absurdity, namely, the morally unacceptable situation of a murderer benefiting from his crime. In effect, the Act was rewritten to say that the issue could not inherit where they had killed to gain this benefit. Advantages of the Golden Rule are: it can ensure that injustices and absurdities arising from the application of the literal rule are corrected. It therefore allows the court to act in accordance with Parliament's true presumed intentions. And thirdly, the broad approach recognises wider social and moral concerns. Disadvantages of the Golden Rule. The obvious problem is that there is no clear definition of absurdity. This is left to the judicial discretion. As a result, the rule is applied in some cases, but not in others. Why not Fisher and Berryman, I hear you shouting at me? The narrow version of the rule has all the same faults as the literal rule. The broad version may be seen as an unacknowledged version of the mischief rule, thus creating a lack of clarity as to the purpose of this rule. The mischief rule. This is an ancient rule, first formulated in Hayden's case. The focus is on the broader issues than the word-based literal rule. Indeed, it is a different approach, and can thus be seen as a forerunner of what is now called the purposive approach to statutory interpretation. Two cases demonstrating how the mischief rule works. First, Smith versus Hughes. Under the Street Offences Act 1959, it was a criminal offence to solicit in a street or public place for the purposes of prostitution. In this case, the women had not been in a street. They were sitting in a house, calling out or tapping on the window to attract the attention of men walking by. If the literal rule was applied, then they were not guilty of an offence. This is because literally they were not in a street or public place. However, Lord Parker took the broader view of the legislation and decided that the aim of the Act was to clean up the streets and allow people to walk along the streets without being solicited or molested. From this perspective, it did not matter where the women were, because the mischief the Act sought to remedy was soliciting. The Royal College of Nursing versus DHSS. The argument in this case related to words in the Abortion Act 1967. These were that pregnancy should be terminated by a registered medical practitioner. By 1972, medical advances meant that surgical abortions were less common, but drug-induced ones had become more common. The latter involved a doctor in the first part of the procedure, but the second stage was carried out by nurses acting on the instructions of a doctor, but without a doctor being present. The question was whether or not this was lawful. The literal approach would have produced a negative answer, but the majority in the House of Lords adopted the mischief approach as follows. The mischief Parliament sought to remedy was the uncertain state of the law prior to 1967 and the large number of illegal and dangerous backstreet abortions. The aim of the Act was to ensure that abortions were carried out with due skill in a hygienic environment. As the procedure in question promoted this wider aim, it was not unlawful. 2 judges applied the literal rule and felt that the majority were not merely interpreting the Act, but redrafting it. Advantages of the mischief rule. It avoids both injustice and absurdity. It takes a wider view than a purely word-based rule. It looks at the context of legislation, and it promotes a more flexible approach to interpretation. It may get closer to Parliament's true intent because it examines broader policy and social implications. And finally, it is more consistent with the European approach to interpretation. Disadvantages of the mischief rule. Until the 1970s, this approach was considered to be less than effective because judges had difficulty in accessing the information needed to examine the wider aims of legislation. This is because extrinsic aids were limited and Hansard couldn't be consulted. The opening up of extrinsic aids has reduced the force of this criticism. Also, Hayden's case is seen as a rather outdated model, especially as it laid down the basic elements of the rule at a time when statutes were a very minor source of the law. The force of this criticism may also have been lessened by the evolution of the mischief rule into the modern purposive approach. The fundamental criticism relates to the role of judges. Supporters of the literal approach take the view that a democratically elected parliament should decide both the remedy and the true reason for the remedy. Otherwise, judges end up becoming unacknowledged legislators. The language rules. Despite their rather off-putting Latin names, the 3 language rules are straightforward and accord with basic common sense. Where specific words are followed by general words, then the general words are to be understood as being limited to the same class, category, type, or group as the specific word. Thus, in the standard example, cats and dogs and other animals, the phrase other animals is limited to animals of the same type as cats and dogs, that is, domestic pets, and not tigers and lions. Thus, in Allen versus Emerson, the issue was whether funfair was covered by the phrase theatre and other places of amusement. As there was only one specific word, the court took the wider view and decided that the legislation covered funfairs even though they do not belong to the same group as theatres. Where a list of specific words is not followed by general words, then the Act only applies to the specified items. Thus, in R versus Inhabitants of Sedgley, a statute dealing with occupiers of lands, houses, tithes and coal mines was held not to apply to any other kind of mine. Words must be understood in their context. Thus, A word of unclear meaning will be understood by looking at related words with which it is connected. Thus, in Inland Revenue Commissioners versus Frere, the issue was with the meaning of the word interest. This word by itself can mean interest paid daily, monthly, quarterly, or annually. However, as part of the following context, interest, annuities, or other annual payments, it was clear that the meaning was limited to annual interest. In addition to the main rules of interpretation and the language rules, judges also make a number of presumptions and assumptions about the law when interpreting statutes. Here is a short list of the main ones. Firstly, that the existing law is not changed beyond what is expressly stated in the Act. Next, the Crown is only bound by an Act if this is expressly stated to be the case. So, the royal family can be prosecuted for speeding because they are bound by the road traffic legislation. Acts of Parliament are presumed not to apply retrospectively. Each Act generally applies only from the date it comes into force. Legislation applies throughout the UK unless Scotland or Northern Ireland are specifically excluded. A good deal of legislative power has now been passed to the Scottish Parliament. If two acts contain conflicting statements, then the court will try to resolve this. The courts do not have the power to repeal one of them. If the conflict cannot be settled, then preference should be given to the later act. There is a presumption that mens rea or intent is required in criminal cases unless the statute expressly states otherwise. In Sweet v. Parsley, the defendant was being charged with managing a building which was being used to smoke cannabis. In fact, she had leased the property to tenants who smoked cannabis without her knowledge. Because she had no knowledge of the smoking, she had no mens rea. The relevant act did not require knowledge, but the court held that mens rea was presumed and the act had not expressly excluded it, so she was not guilty. Changes in the law which affect individual liberties must be expressly stated. There is also a presumption against the removal of vested rights. It is presumed that Parliament intends to give effect to international treaties to which the UK is a party. Also, legislation must be interpreted so it does not conflict with EC law. And lastly, legislation must be interpreted as far as possible to give effect to the European Convention on Human Rights. So, the definition. The purposive approach pioneered by Lord Dengan in the 1950s is an extension of the mischief rule. The aim is for the judge to adopt a more activist attitude to interpretation in order to give effect to Parliament's true intentions. The objective is to make decisions that give effect to the spirit of the law, even if this means paying less attention to specific words of the statute or interpreting against the strict meaning of the words used. Denning sought to interpret the mischief approach broadly so that the courts could carry out Parliament's intentions, what Parliament really meant to achieve, however imperfectly that intent might have been expressed in the actual words used. Criticism. The literal approach dominated interpretation from the 19th century through to at least the 1960s. It is not surprising that Lord Denning's view has been criticised by other judges. There have been three basic criticisms. That judges are in effect acting as unelected legislators. How can judges be so sure that they know what Parliament's intentions are? Judges should not refuse to follow clear words of Parliament. In Duport-Stills v. Sirs, Lord Diplock said, there was no place for a mischief rule where the statute was plain and unambiguous. The impact of Europe and human rights. Despite these criticisms, there has been a significant movement towards the more purposive approach in the last 30 years. One key influence has been European law, where the purposive approach is used. As Lord Denning observed in Bulmer v. Bollinger, all the way through the treaty there are gaps. These have to be filled by judges. The various language in which European regulations and directives are issued also means that their literal approach to words becomes rather difficult, especially since the introduction of the Human Rights Act 1998. Intrinsic and extrinsic aids. The growth of the purposive approach has undoubtedly been helped since the 1970s by the increased judicial access to a much wider range of extrinsic materials. For example, information which is not in the Act itself. Judges have always been able to use intrinsic or internal aids which are within the Act itself. These include the interpretation or definition section in many acts which defines the keywords in the legislation. Extrinsic aids. This is where the main developments have occurred in the last 30 years. It has always been recognised that some sources external to the Act itself can be used, such as previous acts on the same subject, the historical context, earlier case law, and dictionaries of that time. Since 1978, judges have also been able to use the Interpretation Act, which defines commonly used words and phrases. In recent years, the very strict rules that once applied as to which extrinsic aids could be used has been relaxed. A modern judge can now access the following: reports of the Law Commission and other law reform bodies, explanatory notes. These have been produced alongside new draft legislation since 1998. These notes are not part of the Act, but are likely to be used by judges adopting the purposive approach. The use of Hansard. The landmark case of Pepper versus Hart allows judges to consult parliamentary material where the legislation is ambiguous, obscure, or leads to absurdity, and where the material relied on consists of one or more statements by a minister or other promoter of the bill. And, finally, that the statements relied on are clear. International conventions and so forth, which have been incorporated by legislation. Also, EC directives, where legislation gives effect to the directive. This is a major growth area. The Human Rights Act 1998, Section 3 states that so far as it is possible to do, primary and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights.